saying, write it out and you'll find out what law applies. And I said to Brown, does this refer to the Eighth Circuit refusal to tell me the names of the judges on the panel who dumped America in Galgano versus James Dolan, which I appealed? If so, mission is accomplished. Chief Judge capitulated and gave me the names. I had already sued them anyhow. Judges in the United States District Court of Alaska, Glendora versus Benson. I don't know, folks, this is so long, but it is so good. I guess I'm going to give you a synopsis of it. Statement of the case. Plaintiff Nelson Torres Maldonado, like many others before him, has been defrauded of judgment in the Second Circuit of Appeals by staff attorneys and appellate judges themselves, and Glendora is one of the many. A complaint that appears to be endemic to the judgments, quote-unquote, of the Second Circuit is that the issues raised are not the issues addressed. And how? You go down there and you raise the issues of your rights, they ignore them completely and talk about something that you didn't even sue upon. Glendora testifies they have perpetrated the same on her 60 times. Plaintiff Nelson Torres Maldonado has further been deprived of his liberty and property in the obstruction of justice, RICO. You know what RICO stands for, don't you? Racketeer Influence Crime Organization. That's what's going on in the courts. RICO. Conspiracy described herein. Glendora says yes. In one of her cases, they are guilty of the same. Plaintiff Mardelina Sierra, Plaintiff Leilani Sierra, Plaintiff Alice Sierra, and Plaintiff Colin Guerrero have been deprived of their rights to petition the government for the redress of grievances in violation of the First Amendment, U.S. Constitution. That's Madsen and Walker. They have done this to Glendora 60 times. That's when you complain about a judge, they don't file it. Jurisdiction, you don't care about that. The court has jurisdiction for this reason, this reason, and this reason. And now, here's the list of the people and what they do. And I'm just going to summarize that by saying that they're all either United States District Judges in the Southern District of New York, or they are the United States Court of Appeals Circuit Judges, Second Circuit, which covers New York, Connecticut, Vermont, maybe not Vermont, and New York all the way to Buffalo. Jose Cabranes. I stood before him in oral argument, and I didn't know what his first name was, but I happened to use the expression. No way, Jose. Okay, I go through and the list, and I tell my experience with these bums. It's interesting, it's valuable, and but it's detailed, and we just don't have time for all that detail. But you're welcome to a copy of it. And when they said Defendant Honorable James L. Oakes, whenever they said Defendant Honorable so-and-so, I crossed out the Honorable. Here's Bernard Madsen. Defendant Bernard Madsen is the Deputy Clerk of the United States Court, is a deputy. They shouldn't say the deputy. He is a. Courts of Appeal for the Second Circuit with a business address. And, oh, they don't say anything about him here. Okay, it's later on they talk about him. Facts. Now, Plaintiff Maldonado was arrested on April 5th, 1990 and charged with conspiracy to distribute cocaine. At the time of his arrest on the federal charges, he had been incarcerated for 8 months, stemming from state charges in People of the State of New York versus Nelson Maldonado. Well, this bothers me, people of the state of New York. The district attorney, who is the people of the state of New York, okay, defends the people of the state of New York. Her husband is in federal prison. That's Jeanine Pirro, the district attorney of Westchester. Her husband is in federal prison. And she's the lawyer for the people of the state of New York. Plaintiff Maldonado's address resulted from an investigation initiated by the New York Police Department in October 1988, which had received information that East Village Deli, located at 127 Stanton Street, New York, was being used as a narcotics distribution location. These 3 New York City police officers acted in undercover capacities in the investigations. Eventually, the investigation identified key participants, including A. Susan Chang and her lover, Dominic Maldonado, now unrelated to plaintiff Maldonado, in the distribution operation. The ringleader was identified as Robert Cruz, who also known as Lincoln. As a result of the investigation, a number of subjects were arrested on February 14, 1989, most of whom were prosecuted by the New York State Special Narcotics Prosecutor's Office. Plaintiff Maldonado was not arrested with the group. Robert Cruz remains a fugitive. The factual allegations underlying the federal case are identical to those emanating from the state case. The state case was subsequently dismissed in favor of the plaintiff, Maldonado, for lack of evidence. New York City police officer James Mccone initiated the federal criminal case by filing a criminal complaint against plaintiff Maldonado pursuant to Federal Rules of Criminal Procedure 3. Plaintiff Maldonado was indicted on federal charges on April 19, 1990, in case number 90 CR 228. Plaintiff Maldonado was then convicted on October 22, 1990, of 1 count of participating in a conspiracy to distribute and to possess, with intent to distribute, cocaine from August 1988 to April 1990. The only evidence the government produced was the testimony of star witness Susan Chang. Now remember that. That's the only evidence they produced. You know how these trials go. I've told you. Prior to plaintiff Maldonado's trial, Susan Chang had entered into a cooperation agreement with the New York District Attorney's Office. She was released from state custody to work as an informant and was rearrested for selling drugs. She subsequently was released for a second time in order to keep working as an informant. Is that dirty or isn't it dirty? After Susan Chang's second arrest, she was diagnosed with terminal cancer and was told by medical doctors that she had only a few months to live. In return for her testimony in plaintiff Maldonado's case, the state promised to pay her funeral expenses and to place $60,000 in a trust fund for her 8-year-old child. Macabre. On September 10, 1991, a post-trial hearing was held on newly discovered evidence conducted by defendant, the Honorable Leonard B. Sand. Well, I crossed out the Honorable. At the hearing, the defense produced the testimony of Hilda Ruiz and Dominic Maldonado. Mrs. Ruiz testified that she was now the legal guardian of Susan Chang's son, since Chang had passed away. Mrs. Ruiz further testified that Susan Chang had confessed to her that Chang had lied in Plaintiff Maldonado's trial in order to save her blank, 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 and because she didn't want to die in jail. Mrs. Ruiz also testified that Susan Chang told her that the government wanted Chang to give up co-conspirator Lincoln, but that Chang really didn't know where he was. So Chang was going to use the next best thing, which was Plaintiff Maldonado. Dominic Maldonado testified that Susan Chang came over to visit him at Rikers Island and told him that she had lied in Plaintiff Maldonado's trial in order to save her child and because she didn't want to go to jail forever. On September 24, 1991, the defendant, Leonard B. Sand, denied the motion for new trial and sentenced Plaintiff Maldonado to 324 months, 27 years. Numerous 28 U.S. Code 372 complaints for judicial misconduct were filed concerning defendant Leonard B. Sand by plaintiff Myrtelina Sierra, plaintiff Leilani Sierra, plaintiff Alice Sierra, plaintiff Colin Guerrero, and others. These plaintiffs and others mailed their complaints to the Second Circuit Court of Appeals. These complaints were returned unfiled by defendant Deputy Clerk Bernard Madsen with a threat. You are hereby cautioned that continuing to file complaints pursuant to 28 U.S. Code Section 372C containing the same infirmities constitutes an abuse of the judicial complaint procedure and risks the imposition of limitations upon you. See Rule 19A, Rules of the Judicial Council of the Second Circuit, governing complaints against judicial officers under 28 U.S.C. Section 372. This is the very same thing that Madsen did to me last week on my complaint against Mccone. The very same thing. And I have it on audio tape. And he hung up, and he ran away. Bernard Madsen, M-A-D-S-E-N. The same infirmities, quote unquote, were purported to be, quote, your complaint is substantially similar to one posted on an internet site that invites browsers to download the complaint and makes allegations substantially similar to those made in a complaint already dismissed. See docket number 988532. In other words, no one can have the same complaint, and if a deputy clerk determines it to be so, the filing of the complaint will be denied. Well, they're just not going to get away with that. Get him. Defendant Second Circuit Court of Appeals judges have established a pattern of not addressing the issues raised by pro se litigants. Glendora witnesses to the same. Defendant, the Honorable crossed out Alan G. Schwartz, had an opportunity to address the matter of defendant Second Circuit Court of Appeals judges evading the issues raised by pro se litigants in Juan Antonio versus Ralph K. Winter. Indeed, defendant Alan G. Schwartz ignored the plain he gives me a stomach ache. Ignored the plain statutory mandate of 18 U.S. Code Section 3332A, misused the meanings of the words frivolous, quote unquote, and malicious, quote unquote, in order to dismiss that case, and flatly against other issues raised in that case. And that describes them so well, folks. Plaintiff Maldonado believes that law clerks actually adjudicated the Tapia Ortiz case, and defendant Alan G. Swartz merely signed his name to make it official. Plaintiff Maldonado's belief is based on a law journal article written by William Bennett Turner, which states, quote, "The indigent pro se prisoner who believes that he is sending his papers off to a judge for adjudication on the merits is probably misled." Turner, when prisoners sue, a study of the prisoners' Section 1983 suits in the federal courts, 92 Harvard Law Review. Now that we're up to page 10 on that. Do you want to hear the end of this? It's 25 pages. Well, let's take a break and think about it. So I went out to see Franklin, out on the beautiful weather that we're having. Thank you, God. And now we're on page 11. Let's do 10 more pages. This was also likely what happened to United States versus Hansel. The deciding panel, defendants Ellsworth A. Van Grafelen, Dennis G. Jacobs, and Frank L. Parker. Hansel's objection to the presence of a government attorney during the grand jury proceedings fails because Rule 6D of the Federal Rules of Criminal Procedure expressly states that government attorneys may be present while the grand jury is in session. This was not the issue Hansel raised. What Hansel raised was the issue of whether or not Congress had the authority to change the mode of proceeding from what the authors of the indictment by grand jury intended that proceeding to be. Hansel and another litigant, Mike Brown, then you sued the Second Circuit Court of Appeals itself, among other parties, for their dishonesty and obstruction of justice in, quote, evading the issue, unquote, noted herein. Good! And Glendora has sued them multiple times for this. That case, Hansel versus the United States, was then addressed by defendants Frank L. I. Parker and Wilfred Feinberg and James L. Oakes in the following manner. And these people are no good. All of them. Say they. Here the district court reached the proper result because the plaintiff's sparse pleadings reveal no basis for a claim against any of the defendants and no actual controversy with any of the defendants. It is their reply, Glendora says, that is sparse. The existence of a real case or controversy is an irreducible minimum of the jurisdiction of the federal courts, quote unquote. This requirement applies even to requests for declaratory relief. Here, the face of each complaint submitted by the plaintiffs revealed that Hansel has already litigated the issue of Rule 6D's constitutionality and lost, and two, that Brown's conviction occurred more than 20 years ago. No other facts are provided that indicate a current or threatened proceeding against either plaintiff. Indeed, the plaintiffs failed to allege even that they are subject to continuing harm from their existing convictions. Thus, the district court lacked jurisdiction to issue the declaratory relief sought by the plaintiffs. Says Glendora, this is stupid. The statement that Hansel has already litigated the issue of Rule 6D's constitutionality and loss is dishonest and misleading. Once again, the appellate panel refused to address the issue raised. They can't address it because they don't have the answer for it. Continuing harm, quote unquote, flows from any felony conviction these days. the type of judicial dishonesty has not gone unnoticed. No, Glendora reports on it on TV weekly. Before undertaking the unpleasant task of discussing where I believe the district court erred, I find it necessary to undertake the even more unpleasant task of commenting briefly upon my colleague's amended opinion, a substantial portion of which is devoted to a rebuttal of arguments that Pan Am never made. This is quoted from Air Disaster at Lockerbie. In United States versus Hansel, Supra, defendants Van Grafelen, Dennis G. Jacobs, and Frank I. Parker sidestepped the questions of the constitutionality of Federal Rule of Criminal Procedure 6D in their published per curiam opinion. They merely stated that the rule says what it says and nothing more. This type of adjudication is hardly the caliber in which the public is entitled in resolving legal disputes in the United States. This slipshod type of work suspiciously resembles what law clerks or staff attorneys would produce due to their inexperience and lesser qualifications as compared to Article III judges. Right, isn't it? Then in Hansel versus United States Supra, defendants Frank I. Parker, Wilfred Feinberg, James L. Oakes ruled that the issue of Rule 6D's constitutionality had already been adjudicated. They have resorted to being contortion artists of the English language, a method rampant today in American society. In his famous essay, Politics and the English Language, George Orwell wrote, "The great enemy of clear language is insincerity. When there is a gap between one's real and one's declared aims, one turns, as it were, instinctively to long words and exhausted idioms like cuttlefish squirting out ink." History has shown us that other governments have had problems with judges circumventing the law and substituting their own version in oppressing their citizens. Up comes now a quote from Rawson's Dictionary of Euphemisms and Other Double Talk. The bending of the meanings of words is symptomatic of a diseased institution with the angle of linguistic deflection indicating the seriousness of the cancer within. The Spanish Inquisition represented an advanced case. Right? Acumen, will you settle down and be quiet? Plaintiff Maldonado is further informed and believes thereon that staff attorneys, not Article III judges, are the ones actually deciding cases in the Second Circuit Court of Appeals. I testify to that as being completely true. Such decisions are then presented to Article III judges who were approved by Congress for rubber stamp approval, denying plaintiff meaningful access to the courts. You are denied meaningful access to the courts. Defendant U.S. Attorney Mary Jo White and her assistants regularly block, unquote, quote unquote, the access of private citizens to the special grand jury, though private citizens have a statutory right of access to that body. Now you remember Glendora, Bruiser Kid? we asked the U.S. Attorney 28 times to prosecute Bruiser Kent for beating up poor Franklin, socking him in the jaw and knocking him on the floor, and inflicting upon me 6 bruises. And the U.S. Attorney never did. Now that is against the law, because I had a right to access as a private citizen to a special grand jury. Legal claims. Bribing a witness is a felony. You want to know what law that is? Title 18 U.S. Code 201. In order to avoid the possibility of the courts being swamped by criminal defendants victimized by bribed witnesses in suborned perjury, the Federal Circuit Courts of Appeals have changed the meaning of the word whoever in 18 U.S. Code 201 to perpetrate the mess that the Department of Justice and the federal judiciary have made of the criminal justice system. Amen. The law says whoever bribes a witness, and they think whoever doesn't apply to U.S. attorneys, whoever doesn't apply to judges, whoever doesn't apply to clerks. It's stupid. Of course it does. The dishonesty of the federal judiciary in this regard, changing the meaning of the word whoever, quote unquote, in this statute, has spread like a cancer through the federal courts. And so it does. These judges, they have no individuality, they have no independence, they just mimic one another. They just mimic each other. They're clones. We're up to page 15. Nowhere in the legislative history of 18 U.S. Codes 201 is there any basis for writing federal prosecutors out of the statute in order to perpetrate the fraud upon the court and continue the obstruction of justice conspiracy described herein. The federal judges involved had to conjure up common law principles that never existed. Page 17. Supposedly the courts follow the doctrine of stare decisis. That means that if a decision has been made in another case, then it applies to the next case. Well, half of the time you can find just as many cases that say the opposite of what is being argued. You can find just as many cons as they have found pros. So what's stare decisis? What's decision based on previous cases? And anyway, these case law, no, I shouldn't say that. These cases are not law. In the United States of America, Congress makes the laws. The Judicial Department does it. Defendants were not allowed to testify under oath at trial in America until the mid-19th century. Persons charged with crimes and offenses were not competent as witnesses in the United States until 1878. And you remember Jane Ann Murray, and you remember Stewart. What was his name? He was the legal advisor. And they, to help the crooked U.S. attorneys, told Glendora not to testify. Okay, that was bad advice. They never should have done that. That was manipulation. The obvious question here is, if this was such an ingrained practice under the common law in England, why did Congress have to authorize such testimony in a criminal case by statute in 1878? practice, this is a bad practice, the so-called criminal justice system of the government, or the anti-government, I call them, calling a witness who is an accessory to the crime for which the defendant is charged, and having the witness testify under a plea bargain that promised him a reduced sentence. Is that dirty or isn't it? I've said it's dirty. It's dirty, dirty, dirty. And that's what's going on with these gangsters who have taken over our courts. No one acquires a vested or protected right in violation of the Constitution, in long use even when that span of time covers our entire national existence and predates it. Hooray! What the defendant's Second Circuit Court of Appeals judges are doing is a, quote, fraud upon the court, unquote. And Glendora testifies to this. She has personal knowledge of it. 60 times. Now, here we go. Page 19. Defendant Deputy Clerk Bernard Madsen has no right whatsoever to conceal the documents concerning 28 U.S. Code 372C complaints against defendants Leonard Sand by refusing to file them. Concealing a document is a felony pursuant to Title 18 U.S. Code, Section 1503. Plaintiff Myrtelina Sierra, Plaintiff Leilani Sierra, Plaintiff Alice Sierra, and Plaintiff Colin Guerrero have a statutory right to have their 28 U.S. Code Section 372C complaints filed. A procedure such as that engaged in by Defendant Deputy Clerk Bernard Madsen denies citizens their right of access in the courts. Access to the courts must be adequate, effective, and meaningful. Such a procedure denies citizens their right to petition their government for the redress of a grievance. Filing a complaint in court is a form of petitioning activity. The behavior of the defendants named herein has been recognized as violative of federal criminal law since prior to World War II. And this was written by Peny. I recognize her style. And they give cases of this. If the answers to the four questions, so the questions are, Is a litigant entitled to have a judge or panel of judges address the issue raised? Is the deliberate and willful failure to address the issues raised a predicate act under RICO, pursuant to the obstruction of justice statute? Is the unfiling of 28 U.S. Code Section 372 petitions by court clerks a predicate act under RICO? If the answers to the foregoing questions are no, then the court should plainly so state and allow the people, through their elected representative, to correct a court system as corrupt that is worse than totally useless. It is an instrument of oppression. Page 21. Has appeal of right become a mere fig leaf for unbridled exercise of trial court judges? The answer to all of those questions is yes, 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 yes. The answer to that one is yes, too. Declaratory relief. Plaintiff may seek declaratory relief before actual harm occurs if she has a reasonable apprehension of that harm occurring. Plaintiff Maldonado has more than a reasonable apprehension that the deciding panel in any Second Circuit petition he files will not address the issues raised and will rob him of the judgment that is rightfully his. Any proceeding in front of a biased judge is a violation of due process. A judge who is not impartial is a structural error. Structural error requires that a conviction be overturned. This cannot and will not happen in front of Defendant Leonard B. Sand, Defendant Alan G. Schwartz, or Defendant Second Court of Appeals judges, either from bias, corruption, incompetence, or sheer laziness. A judge who is not mentally competent violates due process. Glendora has personal knowledge of all of these judges, that this is their whole problem. I testify to that under penalty of perjury. And I know they are not mentally competent. A RICO enterprise may include courts. Do you know why judges should stand on their heads? So they can turn things over in their minds. The enterprise. The RICO enterprise described herein consists of defendant deputy clerk Bernard Madsen, defendant circuit court judges, the defendant staff attorneys attendant therein, defendant Leonard B. Sand, defendant Alan G. Schwartz, defendant United States Attorney Mary Jo White, and others presently unknown to the plaintiffs. The pattern of racketeering activity. The pattern of racketeering activity appears to be comprised of thousands of predicate acts of extortion and obstruction of justice in violation of 18 U.S. Code 1503, and bribing of witnesses in violation of 18 U.S. Code 201, spanning a time frame of at least 1991 to the present day. The predicate acts. Proof of an explicit promise to perform the official acts in return for the payment is not required. The predicate acts of extortion, obstruction of justice, mail fraud, and wire fraud undoubtedly number in the thousands. This activity has taken and continues to take place from 1989 to 1999. Fraud upon the court. A court can commit fraud upon itself. Under elementary principles of fairness and justice, actions seeking relief from judgments based on alleged fraud upon the court should be treated as continuations of the former action. Nor may the defendants claim immunity from either declaratory relief or criminal prosecution in this action. An action seeking relief from judgment for fraud upon the court, which is brought in the very court that rendered the judgment in favor of the government, the anti-government, should be viewed as a continuation of the former suit. No rule contemplates the abolition by the court. No rule contemplates the abdication by the court of its decision-making responsibility. An individual's right to an impartial and independent tribunal is subject to waiver, like any other fundamental personal right guaranteed by the Constitution. Defendant Alan G. Schwartz has neither the authority to issue a ruling as ludicrous as the one in Juan Antonio, dated October 22, 1998, nor does he have the authority to blindly sign his name to such nonsense authored by a law clerk. A comment from the Almanac of the Federal Judiciary indicates why defendant Alan G. Schwartz would issue such a thing. He favors the anti-government on virtually everything. Nor do the defendant Second Circuit Court of Appeals judges or their replacements have the authority to uphold such a ruling, though it is certainly predictable that they will do so. I testify that all of this is so. Now, the relief requested. Wherefore, plaintiffs request, 1, that plaintiffs be allowed to present their evidence to a special grand jury pursuant to the provision of 18 U.S. Code 3332. That this court convene a grand jury to investigate the crimes complained of herein pursuant to Federal Rules of Criminal Procedure 6A. That this court issue a declaratory judgment pursuant 28 U.S. Code Section 2201 and 2202 that appellate panels must address the issues raised. That the deliberate failure of an appellate panel to address issues raised constitutes obstruction of justice in violation of 18 U.S. Code 1503, denial of meaningful access to the courts, and violation of 18 U.S. Code 1951, pursuant to 28 U.S. Code 2201 and 2202. That defendants Leonard B. Sand and Alan G. Swartz be declared biased and mentally incompetent. That defendants Leonard B. Sand and Alan G. Swartz be compelled to undergo a mental and physical examination pursuant to Federal Rules of Civil Procedures 35A. That all Second Circuit Court of Appeals and District Court judges be recused from adjudicating this action pursuant to 18 U.S. Code 144 and 455, which I've quoted to you many times. That the plaintiffs in this action, pursuant to the provisions of 28 U.S. Code 1331 and 2201 and 2202, be held to have the same rights under Federal Rule of Criminal Procedure as those of a New York City police officer. That this court hold that the word whoever in 18 U.S. Code 201 applies to all government officials, including United States attorneys and assistant United States attorneys. That a special prosecutor be appointed, uncontaminated by any association with any of the judicial or prosecutorial officers in the Second Circuit, to present plaintiff's evidence to the grand jury only. Respectfully submitted, and then the names of the plaintiffs. Well, as you know, I annotated every page of that. I didn't read you my annotations. And under penalty of perjury, Glendora declares she has personal knowledge that this is how things go in the gangsterhood of the Southern District of New York and the Second Circuit. Under penalty of perjury, Glendora tells the truth, the whole truth, and nothing but the truth, and always has, so help her God. God, help all of these reprobates in the United States District Court, Southern District, New York, and the United States Court of Appeals, Second Circuit. Confess, repent, atone, and reform. Dated White Plains, New York, July 12th, year 2001, Anno Domini, yours in truth, Glendora. I'll tell you where I sent this. I sent it to Brown, I sent it to Dadick, I sent it to Madsen, I sent it to Walker. John M. Walker, Jr., cousin of George Bush. Center for Judicial Accountability Incorporated, Orrin Hatch, Glendora TV audience, you, the most important. A matter of justice, Mccone, the administrator of the U.S. courts, Senator Jeffords, the House Judiciary Committee, Gene Crescenzi, and Lori Galgano. I must send one to Maldonado. Omnibus lawsuit. Number 4. United States District Court, District of Hawaii. Plaintiffs. Glendora plaintiff versus John M. Walker, Jr., Chief Judge, Second Circuit. Bernard F. Madsen, Jr., 40 Foley Square, New York, New York, 10007. Jill Hylansky, a law clerk. James Lewis, a law clerk. Gerald E. Rosen, a United States District Judge, 231 Lafayette Boulevard, Detroit, Michigan. James K. Singleton, Jr., a United States District Judge, Anchorage, Alaska. John T. Alphin, a United States District Judge, Buffalo, New York. Michael B. McCasey, a United States District Judge, New York, New York. The Chief Judge and the Chief Clerk of the United States District Court, Philadelphia. Defendants Walker and Madsen are sued for their deliberate and sinister violation of plaintiff's statutory right to 28 U.S. Code 372C1. 2. Defendants Hylansky, Lewis, and Rosen are sued for fraud upon the court, ghostwriting judicial decisions, and deceiving the public that the judge wrote the order, quote unquote. Singleton, Alphin, and McCasey are sued for violating the rights listed in 42 U.S. Code, Section 1983, 1985, 28 U.S. Code 144, 28 U.S. Code 455, refuse to recuse, 28 U.S. Code 372, judicial conduct complaint. Conduct prejudicial to the effective administration of the business of the courts, which business is justice. Rocky, what are you doing? You want to go out, Rocky? Well, just wait a second, okay? And here's a whole list of other ones, the ones that I've listed on TV for you so often. The Philadelphia court is sued for claiming Glendora versus Calabrese was filed in their court when it was filed in the United States District Court, District of Arizona. Rule 8, Federal Rules of Civil Procedure. This is a Rule 8 notice complaint. Glendora has hundreds of pages of documentation the court would be jubilant to read. Madsen is trying to do the same thing to Glendora on 372C1 against Michael B. McCasey, as he is cited for doing in Maldorado versus Sand, the one I just read you. Case cannot be transferred to the United States District Court, Southern District of New York. Not all the action happened in the Southern District of New York. McCasey illegally closed the court to Glendora. She can't file unless she pays $500, and she doesn't have $500. She's in form of pauperous. And 28 U.S. Code, Section 1404, which states clearly a transfer has to be in the interest of justice, and you can't get justice in the United States District Court, Southern District of New York. Glendora will give defendants a chance to do their Federal Rules of Civil Procedure, Rule 4D, civic duty, acknowledge the lawsuit, and waive the cost of serving a summons. But when the defendants turn fugitive, please send the blank summonses and the U.S. Marshal forms to have the Marshal serve them. Wherefore, Rule 8 relief requested is $8,300,000 punitive and compensatory damages, the cost of this action, no more law-breaking by the defendants, together with all further relief just and proper, dated White Plains, New York, July 15th, 2001, Anno Domini, yours in truth, Glendora. And here's the service and the informa pauperis application. Motion. That's it, except for jokes. Why aren't they going to have a Disneyland in Tokyo? Because the seven dwarfs would tower over the natives. Why should your income tax forms be printed on Kleenex? Because you pay through the nose. And why did the inventor cross the TV set with a microwave oven? So he could watch 60 Minutes in a quarter of an hour. And why did the inventor invent the upside-down lighthouse? It's for submarines. This is a chat with Glendora on Monday, July 16th at approximately 6:30 p.m. The LPGA is cranking up. The program, 6 of them, 6 half hours, and get them ready for 22 cable TV stations. Acumen, I was helping Franklin upstairs. Franklin thinks there's something wrong with his eyes that make him dizzy. And so I was helping Franklin upstairs, and Acumen doesn't like to have us go away and leave him, and he was barking. And then when I got through helping Franklin, I came downstairs to help Acumen, and he'd gone. He chewed his way through the rope on the chain, I guess, and then he dug his way underneath the fence. And he's gone. I went on foot looking for him, but he didn't turn up. I had an appointment at 7:30, got back from that around 8, and I looked for him for, an hour. And then I called the police, and Officer Fowler took the report. And here it is, 7:45 a.m., 12 hours later. And I'm in Lynbrook, and I don't know where he is. I called the police way into the night, and a policeman came to the door, but nobody found the dog.
Well, after giving you our closing credits, this marvelous audience here in Dallas, Texas, asked us back for one more set for those of you in the music business. And so we're going to run this videotape out to the end. You're looking at about another 80 minutes or so of information. Same goes with the audio. We are very, very grateful for your gracious reception of our material. We are very grateful for your kind support. And to take us to the end of the tapes, back by popular demand, the managing general partner of the law firm Loot, Rape, Pillage, Steal, Double Talk, Drawdown, and Ripoff, Mr. Double Talk himself, Arthur Deranged Rogers. Thank you.
Okay, I guess we're just supposed to ad-lib, so this is pretty much a free-for-all. What Peter's handing out to you right now is this thing by Gail Stanaki, which happens to be one of the original do-it-yourselfers. She did a great job on a council issue, and also they were trying to put her in for a mental observation position, which I've been in. But it did raise the issue up that we haven't covered really thoroughly, which is counsel. And because it's such an effective tool, it deserves probably an entire seminar on its own. Counsel, if it's done right, never fails. In fact, because the law is so persistent on it that the assistance of counsel in your defense is absolutely mandated under the constitutional provisions of both state and federal law. Yet every effect or every use of counsel in the legal system that we presently operate under is meant for appearances or for representative purposes. Yet you'll note that the terms used in the law says that in all criminal prosecutions, the accused shall enjoy the assistance of counsel in his defense. Nowhere does it ever refer to representation, and nowhere does it appear or does it refer to appearances. It is strictly assistance. So if you strip the language down and got away from the modifiers, the law would now read, in all criminal prosecutions, the accused shall enjoy assistance in his defense. It would still be a complete sentence. It would totally be logical. What they've done is use the word counsel to mean, in most jurisdictions, only lawyers licensed to practice law. So it even excludes those not licensed to practice. In Minnesota procedural law, the court rules, if you will, it says in the rules itself, under definitions, that where these rules refer to counsel, it means an attorney licensed at bar to practice law in this jurisdiction. So with all of that in mind, and then of course you start reading the case law, there's a plethora of case law out there that usually deals with a very narrow issue. in each particular case. So there's although I don't recall the names offhand, there's one particular case I recall reading that said that an individual who operates as counsel for himself has a fool for a client, so to speak, which is an old adage in civil law. But nonetheless, he has a right to make a fool of himself. So these are very succinct statements, but they're also very narrow. Another one they use is one I always use, I think it's Argensinger v. Hamlin, which says that let every court in the land know that from this day forward, whenever the trial of a misdemeanor starts, that no imprisonment may be imposed, even though local law permits it, unless the accused is, and I quote, represented by counsel. Now, in Minnesota statute law, they use this quote to support the position that the court can assign court-appointed counsel so that they can effectively imprison you unless you, if you will, eloquently waive counsel. One of the first issues the judge will bring up is whether or not you have a licensed attorney or whether or not you have an attorney. And if you say, no, I merely have my friends here to assist me, they wants to know if they're licensed, which for his purposes is to satisfy the requirement that everybody who's going to be charged criminally is at least afforded assistance, or I should say afforded representation. So what I've done is develop, and I do have a counsel brief that we did about 8 or 10 years ago that we haven't finished pruning yet. We're working on it. But nonetheless, my position is that counsel is neither representative nor is it by appearance. That counsel is strictly the assistance in the exercise. And the exercise, of course, is counsel. But if you were to put that in normal linguistics, we usually try to afford them some idea of what we anticipate counsel is for. Yeah.
I've heard from one source that the right is not to counsel, the right is to assistance.
That's correct.
Yeah.
In fact, I was probably the source. Anyhow, but I'm notorious for leaving the word counsel out of the phrase entirely. So in the courtroom, I usually refer to it as I'm required by law to be afforded assistance in prosecuting my defense or in prosecuting my claim, because this works both ways. In most jurisdictions, though, they're going to try to get you to work in this licensed world. So they'll ask, do you want the court to appoint you an attorney to represent you, or a lawyer to represent you, as the case may be. And because the verbiage is so susceptible to misuse, my response is usually in the nature of, I don't understand what you're asking me. Are you saying that counsel is the same as an attorney or a lawyer? And invariably the answer is yes. So then I reverse it and I say, were they the same, I should be able to interpose the words. And in that sense, could be fairly stated that I could say that I'm going to I'm going to counsel with my lawyer, or I could counsel with my attorney, to which they'll answer in the affirmative. But if I were to interpose those things and say that I'm to lawyer with my counsel, it somehow doesn't taste right. Or I'm to, what we say, attorney with my counsel. So obviously there's some distinctions in these words and how they're used. Now, counsel is an exercise, is my phraseology. So I'm always afraid to represent that I understand what they mean. And because it's beyond me to afford my fellow countrymen an expense that isn't by law one that they're required to pay. For instance, if the court appoints me an attorney, somebody's got to pay for it. So one of the issues you can raise to bar this is that it's not lawful for me to obligate my fellow countrymen for something that I can do without. Obviously, if I have my friends here to assist me, I certainly wouldn't obligate my fellow countrymen to pay the expense of a lawyer. I get tongue-tied. But in any event, if I have a lawyer representing me, then is the lawyer going to suffer all of the indignities and the penalties this court's going to bring upon me in the event I'm convicted? And of course the answer is no. Well, then what is his purpose? Well, it's to fully protect all of your rights. Well, if one of my rights is to assistance and I want him to assist me, how does the lawyer ensure that he can assist me? To which there's no real answer, and they won't answer it. So usually they'll accuse you of doublespeak or twisting the words. And I say, no, I think you're wrong. I'm twisting the understanding of the words. You see, I don't understand how you can say that counsel is not a lawyer. And he said, well, counsel is a lawyer. Well, then how can the lawyer afford me the assistance of my friend if he's not worth even that? I mean, if he can't get my friend to help me, what the hell else is he going to do? Well, he'll represent you in these proceedings. He'll cross-examine witnesses. He'll bring motions. I said, I'm fully capable of all these motions on my own. I can walk right out of here, right? That's all. I'm convicted. And of course the answer is no. Well then, what is his purpose? Well, it's to fully protect all of your rights. Well, if one of my rights is to assistance and I want him to assist me, how does the lawyer ensure that he can assist me? To which there's no real answer, and they won't answer it. So usually they'll accuse you of doublespeak or twisting the words, and I say, no, I think you're wrong. I'm twisting the understanding of the words. You see, I don't understand how you can say that counsel is not a lawyer. And he said, well, counsel is a lawyer. Well, then how can the lawyer afford me the assistance of my friend if he's not worth even that? I mean, if he can't get my friend to help me, what the hell else is he going to do? Well, he'll represent you in these proceedings. He'll cross-examine witnesses. He'll bring motions. I said, I'm fully capable of all these motions on my own. I can walk right out of here, right? That's all the motion I'd like. Nonetheless, if you get the lawyer upset with you, now I've had public defenders that have told the judge that if you assign me to represent this man, I'll quit. Because the next thing I do is interview you. So, there you go. But the lawyer that's being interviewed is really under the gun, because I want to know his particulars. You know, if he's old or if he's young, if he's married, would he mind if I played with his wife while he represented me, or whatever you want to ask him. Usually I'm very sly about it, and I ask him leading and suggestive questions like, how many cases like this have you won? And of course he said, well, I don't understand the question. And of course you admit that you jumped the gun. How many cases with me have you been involved in? Because that's the only cases like this you could have won. So then it's very pointed. In other words, have you the capability of properly presenting a defense in this case, or properly defending a plaintiff's position? You know, he can't very well say no. So his answer is always yes, and then you say, well, I'd like a demonstration of how that goes. And most of these guys are real weenie. You know, they do the statutory things, you know, that the law doesn't apply in this instance, or this man was entrapped. They'll do all those things. And then when I tell them that I want to confess to the jury that I'm a compulsive pathological liar as a condition of me testifying, you know, he said, well, I couldn't win the case then. I said, thank you very much. Go back and tell the judge that you couldn't win this case. Doesn't matter. You're going to get rid of him, right? And he's obligated, if he can't win the case, or even have a fair shot at winning it, of not pretending to represent you. So nonetheless, some of these things have been practiced for a long time. We spent probably 3 days interviewing one attorney because we didn't know how to get rid of him. And this guy was playing hardball. He was a public defender that was 2 months away from retiring. And he begged the judge in open court not to put him on this case because he thought the case would go more than 2 months. And this is really just a parking ticket. But because of the issues we were requiring that they raise, in other words, we're saying that the city can't bring an action in this particular because the city wasn't properly incorporated. that the city attorney wasn't properly licensed, that the city attorney had an axe to grind, that the city attorney profited by parking tickets, and on and on. This is just, yeah, go ahead.
May I share how I got rid of a lawyer that was court appointed? I took him over in the corner and I said, if you interfere in my case, I will take your license, if he had one, if I can, and I will sue you for sure. And he got off my case, and the prosecutor had to dismiss my case. Felony. And the prosecutor dismissed my case.
Very good. See, more people should have what you have, but most of these men walk around with empty pouches. In either event, most the ladies that I've worked with have a lot more upstairs than most guys have downstairs. If you've had the opportunity to work with some of these women, they can be real tigers in the courtroom. Yeah, just right. Most of them are real tigers out of the courtroom too. But nonetheless, as we've gone through this lawyer thing, and you get the option of interviewing them, and they have a chance to disqualify themselves. Once they're familiar with who you are, they always try to disqualify themselves. So I've had one say that his wife was relating that she would like to go out with me so that he would likely not do as good a job. And I mean, it was pretty reaching considering he was near 70. But, you know, this is not uncommon. Now, anyhow, the idea is that they will impose on you, particularly in the federal system. You'll be given a federal public defender, and you'll like it or leave it. And so now the choice is, can you make him work? And so I've actually sat with federal public defenders where they enjoyed this. You know, they said, hell, whatever you guys want to do. And, of course, the first thing we want to do is you to volunteer that you're incompetent so that you can't possibly provide a defense, which if the lawyer admitted to would probably get disbarred. Nonetheless, you start drawing up paperwork and making him sign it, it's apparent he's incompetent, right? So either way, you know, he'll always, if the lawyer submits paperwork, the judge will always order, or excuse me, if the individual submits paperwork, the judge will always order that the lawyer signature it, which is another way you can drag him in and drag him out. And invariably, if you wrote something that was really hokey, you know, that they just can't bring themselves to sign. And it can be some of these patriot mythology things if you want. And the lawyer says, I can't sign that. And you insist on putting it in, the judge will reject it. See, now you're not allowed to file documents, and you're already building this reversible error concept. Because if you're not entitled to file documents which you feel are germane to the case, and the lawyer either stymies you or the court stymies you, you've got procedural error. And that's all you're really after. Create the error if you can, make the error if they won't. Works fine. In any event, these lawyers have got a brotherhood going that almost nobody's been able to fracture. This is one of the worst states. In Florida, if you're a pro se, they have a Pro Se's United or something in Florida. In fact, I've got the court case in my suitcase somewhere, where they actually have a court order, standing court order in West Palm Beach County, that if you're a pro se, you have to have a guard, a county guard, or a deputy sheriff, be with you at all times while you're in the courthouse. And this is a standing order in that county. So they definitely have learned to hate pro se's. Nonetheless, I've had the misfortune of having no lawyers ever represent me, which is, you know, one of those novelty things. I've had several of them that said they'd like to, and yet I couldn't find them qualified enough. I've had them on standby in the back of the courtroom, to where as soon as they were standing by, I would add insult to the injury. I'd ask the judge to have all surplus personnel removed from the courtroom. And of course, invariably they leave him, and I'd say, well, he's armed, and I'm frightened because he has armament on, because they usually disarm police officers in the courtroom too. And they say, well, what do you mean he's armed? I said, well, yeah, he's armed with ignorance. And he's standing back there insulting my intelligence. You know, so I can't deal with this. Because they want you to say that if you need counsel, you're going to rely on him. And in the federal courts, this is particularly heinous. If you want counsel, you have to use a licensed whore. So obviously, if you're good at this and you understand how it works, you would spend all your time running back and forth between him and the bar, right? And of course, you're just going back there to ask him if he's still here. They don't have to know what you're asking, because that's private. Now, how long you can do that depends on how patient the judge is, and will he interfere with the exercise of the right to assistance. Okay. And or you can send him out for coffee, for lunch, for help, for anything you want. But some of these lawyers get downright fed up with it, and they think this is a malicious use or misuse. But if you were being burdened, let's say that you had to carry the mule instead of the mule carry you, what would you do? Wouldn't you buck a little? Right. So we try to get people mentally prepared that if you're going to be saddled with this lawyer, the worst thing you can do is not object. If you're going to put up with it, you deserve what you got. On the other hand, you can't refuse him because they'll put on the document that you refused counsel and that you insisted on appearing alone. So it always must be that I need assistance, and I would not know how to proceed without assistance. Yeah.
In my federal case, when that issue was...
That's right, you went through this, okay.
Yeah, that's right, I did work through it.
I forgot about you, yeah.
But I got to the point where Barefoot Sanders just said, "Marshals, remove this man." And I was out of there on that council issue alone. But that was because I was facing off with them about the whole thing. Because you're absolutely right, they will press you real hard on that matter, but I was unrelenting on it, so you know, he just had the marshals remove me.
Oh yeah, they'll ask you, have you ever read the rules of federal criminal code, criminal procedure? And if not, then obviously you're not qualified. Right? So I always tell them I've read every word in the dictionary, but I don't recall the sequence they were in. If I remember, it started with the A's, the B's, and the C's, but I don't know what followed one another other than general principles. So having read the dictionary, I've obviously read every word in the federal rules of criminal procedure. Right. But not that I understood it.
I just would mention in parting that ultimately, and Dwayne was just touched on it, that I ended up defending myself in that case, and that was without an attorney.
You survived, all right. Most people that have been forced into this don't... Oh, I'm sorry, go ahead.
I got a question here. Does everybody that appears in court have to be with counsel as one of them card-carrying morons?
You mean, are they card-carrying morons?
Yeah.
Usually. Anybody that appears in court, by definition, is a party. Or made a party. Appearances are what they're talking about.
Get your Law's Black Dictionary, 6th edition, look up jailhouse lawyer.
Sure.
And it's been upheld by the Supreme Court.
Sure. Except I'm neither a liar nor a lawyer.
Well, I know it, but it's just the idea that the fact is you don't have to be a card-carrying moron to be in court.
That's true. In fact, you usually have to be a moron to stay in court.
Well, why can't we all be up there non-carrying morons?
I would. You know, I just don't need a card to identify who I ain't.
Another thing to do, I went to court in Fort Worth, and they told 12 of us defendants that if we did not have a lawyer, and they do this routinely in Fort Worth, you automatically go back to jail. I don't care if you are on bond, you go to jail if you do not come with a lawyer. Everybody else came back next week with a lawyer. They brought me back about 3 times, and finally I put a huge Bible on the bench and said, "Judge, I cannot take a lawyer because Luke 11:46, Jesus says, you lawyers put a burden on the people and you lift not one finger to lighten that burden." And I said, I can't afford any more burdens. I can't take a lawyer.
Well, you know, she's got a good point. If you're out to obey the law, you're going to wind up in jail. In fact, you can't do what I do without going to jail. So, you know, count the cost. On the other hand, you're probably going to go to jail anyhow, even doing what you do. So it's not always bad as it seems. Every time I've been put in, most of the jailers were extremely sympathetic. I've never really had any mistreatment. Some people have. Well, a couple of these guys had squeaky voices for quite some time, just being near these jails. Nonetheless, yeah.
I got something I've been working on in my mind for a while, and I'm wondering, one of the things I want to do is I want to just present an affidavit, and I've been thinking about it for a long time, just haven't got around to it. Points out that the State Bar of Texas is a criminal organization, insofar as it clearly violates a number of provisions of the Constitution. And you can point them out, there's no question. I think it's maybe Article 1, Section 26, monopolies are contrary to the genius of a free government and shall never be allowed. All right, that's in the Constitution. State Bar is admittedly, time and time again, a monopoly. And there's a couple others in here. There's probably 3 or 4 in the bar or in the Bill of Rights. And what I'm thinking about, prepare an affidavit or whatever, but at least the argument that it is therefore a criminal organization. And that being the case, therefore, every attorney who is at least aware of the fact that that organization is breaking the law strikes me as a member of a criminal organization. Strikes me that maybe under equity, under that clean hands doctrine, Maybe say, I don't want him. He's a member of a criminal organization. I don't know if that would fly or not, and I'm not even competent to guess, but I'm curious to whether it makes any sense to you or whether it just sounds too far-fetched to go with
No, in fact, it hits me right smack dead in the alley, because I don't have any trouble with that at all. I would just add a little bit to it. In other words, the right of the people to be secure in a person's houses, papers, and effects is infringed by monopolies, and the Constitution prohibits it. That Section 29 prohibits any law, including this judiciary, from writing such a law that would give them a monopoly, or if it would even discriminate between those with or without bar cards. Because quite honestly, when my son is in court, they put right on the record that I was being his representative, to which we would disagree. I said that I'm here to ensure that there's a remedy in the law for every injury to person, property, or character. No, this bar association is so corrupt, and it permeates almost every state. The Article 2 of the Constitution for the state also provides that members of the judiciary, members of the executive, and members of the executive cannot cross lines. So here's a member of the executive branch of government, the Attorney General's office, who's a practicing lawyer. That obviously is in violation of separation of powers. So no, I would only add more salt to the wound. In fact, I'm so twisted I'd probably add about 10 more of them, because that's what it takes. Yes, sir.
But you also have to check each state for their State Bar Act, check the voting records of the legislators that voted for that act. If they did not sign a conflict of interest statement in voting for that act, they could probably well be overturned.
Good possibility. Now, although the bar is the one that makes the determination whether or not they were doing anything wrong. You know, it's like, it's like asking the fox to guard the hen house. Or, in any case, every time I get into this argument with the lawyers, we have this discussion with how unlawful it is. But you realize that you can't be required to have somebody represent you because it's unlawful for you to pay them with my money. Because it's an act of theft done by device. So thou shalt not steal.
What's the implications if the judge does say, refuse assistance or refuse counsel?
Yeah, now it's a matter of question and answers. Would you deny me the lawful exercise that you swore an oath to uphold? And he'll say, you can't have anybody represent you except their licensed bar, to which you need to clarify. Excuse me, I'm afraid that nobody could represent me. It would be unlawful for me to burden anyone with my faults. So I would neither let him represent nor appear. What I would require is that the individual accountable in the exercise is held accountable. In other words, upon what individual do you rely for your authority? It's real easy. But you just don't have to, what we say, accept what he said. If he says no, that means it's more argument. When he says yes, then you don't have to argue anymore.
As a practical matter, he brought up a very important issue, because typically what they'll do is they'll try and steamroll you, and they'll try real hard, and if you typically they have that capability of almost running right over you, unless you're Dwayne Rogers himself. But when they did that to me in Missouri, and they said, well, you're refusing assistance to counsel, or he said, how do you put it? He put it that I was waiving assistance to counsel. And I said, I'm not waiving assistance to counsel. I'm insisting on assistance to counsel, and you've sent my counsel back into the audience area. Well, what he did was he entered on the docket
that you waived counsel.
That I waived counsel. Now, this is the practical matter that I'm getting to share with everybody, and that is that what you can do is you get a hold of a copy of that part of the docket where he did that, and you file an affidavit of falsification of the record.
Amen.
And every time they do that kind of stuff, you file an affidavit of falsification on the record. And he cannot come back and dispute it, and pretty soon you have a record that goes bing, 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 falsification of the record, falsification of the record, falsification of the record. Now what do you have?
Yeah, the very definition of lawyer implies that you have a client-ward relationship. So you can also bring a complaint for misconduct. And you just do it before the Bar Association. And what it is what we say, imposing the lawyer's will on the client, which is obviously what they're doing. And you can bring it against the judge, who is a practicing lawyer, but he's not, if you will, currently in private practice. So now you've got all these conflicts. If they're officers of the court, members of the executive on the one hand, almost invariably the executive branch of government generates the pay for the public defender's office. So now you have more members of the executive practicing, if you will, law, which is a crime. If you report them to respective bar associations for imposing their will unlawfully upon a client, it's mishandling of public funds. So they're taking money for it. See? And of course, at the same time, they're misrepresenting that they're being paid, when anybody that has half an ounce of sense would know that they're only being discharged. It goes on and on and on. So it's unending. It's a nightmare they haven't begun to live yet. Go ahead.
Well, to show a little bit more how this nightmare works, there was a gentleman out in my county that got arrested for some superfluous garbage. Anyway, he went to jail, and he was there for 5.5 months arguing. Well, he was in jail. He never could get out because he kept arguing with him every time he went in there about the jurisdiction area. When it came to the court appointing him an attorney, he refused the attorney. The attorney refused or requested the court to take him off the case. The gentleman tried to get the attorney to get him off, or tried to get the judge to allow the attorney off the case, you know, by just constantly refusing to have him say anything for him. This went back and forth for a couple of times. Finally, the judge says, no, the attorney's this is going to be your attorney whether the attorney likes it or not. And you're going to accept him whether you like him or not. And if you argue about it, when the jury's in the room, you're going in the hall, and the attorney will take care of the case. And that's exactly how they did it.
But, you know, the fact that they're unlawful, notwithstanding, you know, most people think that holding up the cross makes the devil go away. And really all it does is bring out the best in him. You know, when you argue with one of these mental midgets, the result is exactly what a mental midget would do. You can't expect any less. So you have to count the cost. Sometimes it's not a good thing to argue with. The fact that Michael points this out, that this jurisdiction stems from .44 caliber, and whether you like it or not, your calibers are smaller and less. So you're stuck in this morass of being right and being in jail. And I always point out that the Messiah was correct, and they hung him for it. So thinking that you're correct is not going to keep you out of trouble. But you can get protection where you never thought it was possible. And I mean, I have several examples of things I should never have gotten away with that just miraculously seem to occur. So I accept that that's the normal. For anybody that decides that he wants to keep the covenant, you can expect the unexpected. But don't think it'll be what serves you. And I've been in some real rat holes where I came out smelling like a rose. Should never have happened. But nonetheless, I expect it anyhow. I can't imagine how fearful I've been, even getting thrown in the federal stir. I mean, I shook like a leaf. I couldn't believe I could be so cowardly inside. Well, these people were quaking outside. I don't understand this. But nonetheless, I am. And I did. And I regret that I did, but you know, I'm just human. But the council thing was one of the fail-safes that I've always been able to fall back on, that they've never successfully defended. When they see the appellate work coming through on council, almost invariably they'll find another reason to turn the case over. So if you could put every gap or every hole in their defense, all they have is gaps. They don't have a defense. So it's like denying you witnesses. It's denying you assistance. It's denying you subpoenas. It's denying you time. It's denying you evidence. It's not uncommon to have this thing set in front of the judge for 6 months, and it comes up to the day of trial, and then the first thing that comes out of my mouth is we have procedural matters to take on before trial. And one of those is I want to hear all motions brought before trial again, and they'll just deny them all. One of the most hilarious ones, we had put in about 20 motions in a trial, and we had put in a motion for a fair trial. And the judge denied the motion for a fair trial. Now, even though the guy was convicted, when it started going up on appeal, the mysterious happened. They found due process violations, not fair trial, because you can imagine how stupid the judge would look by denying a motion for a fair trial. So you have to expect the unexpected. And it's just bizarre how it works out. We had a policeman who had roughed up a friend of mine, threw him in a police car, and my friend was a big man, and he kept right on running. So when he got thrown in the police car, he just went right on through it. So it's in one side and out the window on the other side. Anyhow, they were trying to get him for, you know, damaging public property and all the rest of it. And so we had laid in a bunch of evidentiary work. So we had glass samples that weren't real, by the way. These people cleaned up the track so fast that they didn't know we had these glass samples. We put some daubs of blood on it. We sent it off to the lab. And we had this thing set up to hang this guy. The day of trial shows up, the police officer doesn't show up. So they postpone the trial, and it's postponed for like 10 days. We show up again, and the police officer is sick. So, which is a good excuse if you can, you know, substantiate it. But right after that closed, the prosecutor came up and said, well, we'll make a deal with you if you'll just plead to this lesser charge. And we said, no, we thought that anybody that would damage a public property ought to pay for it. So we wanted to go through trial. And so a couple days later, we got a notice in the mail that the trial had been nulliprost because the police officer hadn't showed up twice. So the judge made the decision, or I should say the prosecutor made the decision to confide in the judge. And of course, you could go to jail for 2 years or 3 years, whatever they want, for whatever they want to impose on you. But this is more common than not if you start messing with them. Just learn those rules and play court. I mean, you'd be amazed the damage you can cause if you just continue to play court while you're in there. It's just a show. And these guys love their formalities. One of my nicer things that I do is I'm like this character back here, and I don't take off my hat. So usually that causes a stir, and a bailiff wants to come over and snatch the hat off your head. If you know he's going to do it, of course, you want to put a wig or something under it so that you know, put something icky on your head, like a little skull cap, and put the wig over it and put the hat on it. And he snatches it off. Now he's embarrassed you publicly. Because you're not required to move your hat in a courtroom. We have a guy that was told to remove his hat, and instead he has this real greasy old, I don't know what you call it, the thing would walk on its own. But anyhow, he's in the courtroom, and they order him to take this hat off. And he says, you know, it's my spiritual belief not to remove my hat and embarrass myself in public. So we're sitting in a jury box because this courtroom is so crowded. And so everybody in the courtroom can see what's going on in this jury box. And this is just arraignment day. So he's sitting there, and the judge insists that they'll throw him in jail for contempt. So he takes this big old yellow handkerchief out of his pocket, and it's only yellow from its use. And he slides it up under the hat and pulls it down like Madonna's scarf and takes his hat off. So now here's this judge looking at this man with a scarf on, right? Neatly tied under his chin. And this went on for maybe 20 minutes until the snickers in the audience got louder and louder and louder. And finally the judge agreed with him that he could wear the hat. It was less offensive, but he did take the hat off. So, you know, he wasn't trying to be in contempt, but he looked so gruesome. I mean, this guy's fully bearded, and, you know, and of course this well-used handkerchief did the job. Yes, sir.
How about have your wife or lady friend wearing a hat, and when they make you remove your hat, then don't we have a sexual discrimination thing?
It could work if they wear them. You know, usually they definitely only pick on the men with the hats. So that might be another way of doing it. Not rising is another thing that upsets judges. The first thing the bailiff does coming into most courtrooms is say, all rise, in his best intoned, inflected voice. And of course, if you're hard of hearing or whatever, the bailiff will wake you up. You know, get up, get up, get up. And of course, you just look at him with disdain. And of course, eventually we brought to the attention of the judge. Now, the first few times I did this, they didn't say anything other than give me scowls. Finally, the judge asked that I stay in the courtroom after everybody's dismissed, and he informed me that the next time I did that, he was going to hold me in contempt. So I acknowledged I had heard him, and I just sat there. And the court's convened, and it's just to see who. This is the judge that I called a thief earlier, so he was out to get me anyhow. But anyhow, I wait for the court to be convened, and I was sitting there again, and I didn't get up. And the bailiff comes over there and said, the judge says that I'm to arrest you for contempt of court. I said, that's nice. And he said, well, come with me. I said, no, if I'm in contempt, there should be something on the record that makes me contemptuous. So he reaches down and tries to drag me up with the arms, and these are wooden benches, so I raise my foot, and it locks on the bottom of the bench, but it does so with a resounding clunk. You know, and now everybody's focused on me. And I slip my shoulder up so he's got me by the ear instead of by the shoulder, and he looks for all the world like an assault artist. In any event, he's doing his best to, you know, look controlled, and I'm hanging onto the bench with my feet. I'm not making any motions with my hand. I'm just sitting there passively. And you can't see what my feet are doing. But this guy can't budge me in any event, and now he's, you know, starting to get into this wrestling contest. But at the same time, my sons were in the courtroom, and they were young at the time, and so the deputies had seized upon them, and they just levitated them. So they were now held in the air with their legs crossed because they don't stand either. And so they finally carted me off out of the courtroom after all this squabble. And now my question was, what's the charge? You know? And he said, well, it's failure to take off your hat. So it looked nice on the statute book, won't it? And county attorney or assistant county attorney's out in the hallway, and he hears me comment on this, and he headed right for the law library. They didn't get me in the cell, and they were already releasing me. and it was okay to go back upstairs, and I'm out there cussing at them because they don't even know how to arrest me right. And because I've been trying for a long time to get into this particular situation, because it's cut and dry. With no statute, it's a false arrest, period. And so anyhow, they drug me back up into the courtroom, and now everybody knows what went on, and I promptly sat down again, which is what you're supposed to do. And so when they got ready to go out again, I asked that the judge stay in there while everybody else went out, loud enough so everybody could hear, because they had heard this before. And when he got, I gave him my condolences for not knowing enough about the law to at least, make this thing stick. So he's not an arrogant man. He knows when he's been nailed. And he looks around the courtroom and sees nobody else is there, and he says, "I'll get you, son of a bitch." 2 hours later, we're out in the hallway, and he hears me talking to somebody about what he should and shouldn't do in the courtroom. And he comes up and he says, "I think we have enough evidence to arrest you for practicing law without a license." And my heart fell, because I had just told this guy, when you go in there, don't plead, et cetera, et cetera, et cetera. And now I at last was going to get my chance. They were going to actually charge me. So I got up my best composure up, and I said, "Do you want me to follow you into the jail, or are you going to arrest me personally?" He said, "No, I'm going to prefer charges with the Bar Association." And I just said, yeah. So here's the Bar Association as the complainant in the criminal case. And what's this awesome crime I've committed? Well, I have a judge saying that it's practicing law. Okay. Now, is a judge qualified to define the practice of law? I think not. And all he can do is observe the trial for the practice of law. So now we got our first witness. So I informed him that I would call him as a witness and that I would be very appreciative of his help, because he most certainly, and he said, and walks off. But this thing stems from this council issue. Every time I'm in that courthouse, they know that somebody in there is not going to be doing what they think they're going to be doing. So at one point we were about ready to have flyers out, have gun will travel type flyers, except have help or need help, call so-and-so. And yet the sheriff came up, and we heard us talking about this. He came up and he said, "You'll not put that in this courthouse as long as I'm sheriff in this county," which made me wonder why and whose courthouse this was. How many people live in that county that would need help, as opposed to how many people live in that county who are capable of denying help to them? But we never got any further than that. We were going to put it in the newspaper. Just post an ad. If you're being charged and you feel it's unfair, if you've got a lawyer and you feel that he's unfair, call so-and-so. I'll bet you'd get 1,000 calls even in this weeny little county. On the other hand, who knows? I have enough people coming to my door as it is. It's incredible. The neat part is that most certainly. And he said, and walks off. But this thing stems from this council issue. Every time I'm in that courthouse, they know that somebody in there is not going to be doing what they think they're going to be doing. Right? So at one point we were about ready to have flyers out, you know, have gun will travel type flyers, except have help or need help, you know, call so-and-so. And yet the sheriff came up, and we heard us talking about this. He came up and he said, "You'll not put that in this courthouse as long as I'm sheriff in this county," which made me wonder why and whose courthouse this was. You know, how many people live in that county that would need help, as opposed to how many people live in that county who are capable of denying help to them? But we never got any further than that. We were going to put it in the newspaper, just post an ad. If you're being charged and you feel it's unfair, if you've got a lawyer and you feel that he's unfair, call so-and-so. I'll bet you'd get 1,000 calls even in this weeny little county. On the other hand, who knows? I have enough people coming to my door as it is. It's incredible. The neat part is that when they start hearing what you're doing, some of them will support you secretly. So there's some rather, what we say, high-placed people in the county that come to you and ask if you need anything, so you can keep doing this. You know? And they said somebody's got to keep the fires burning. Although I don't want to go to jail or anything, I don't know how to stop either. Honestly, I can't stop doing what I'm doing. Who else had a question? We had one other guy. Oh, he disappeared. Oh, all right.
Kind of a comment question along the lines of counsel. I heard a story recently about someone, and he was arrested and went to trial, and he trained and said that he wasn't really that confident in doing certain techniques because he'd get too nervous in the courtroom. And the judge said, well, you know, we're going to have to get you an attorney to represent you. And he goes, well, gee, that's really nice of you, Your Honor. But the only thing is, I'd have to interview this attorney under oath, since you're paying for him and you're my adversary, the state's my adversary, would that be okay? And the judge goes, yeah, and they called out a guy, and then they brought him on the stand, and this may be part of the patriot mythology that you're talking about, but what he asked was that, you know, well, my plan of defense is that I'm going to make a counterclaim against the government that the government went bankrupt, and I want to know if you can represent me in this way. And apparently the lawyer just looked at the judge and he said, well, you know, my caseload's actually quite a bit higher than I thought it was. And the judge said, well, you know, we'll just take this up at a later date, and never heard back on it.
I've heard the story before, though. Yeah, and I think for the most part...
I just want to get your comments on it.
Oh, no, it works very effectively. If you give him an impossible task or something that he's ignorant of, they'll just cop out. They want out. There are a few. I had a public defender in Minnesota who just liked working with me. And I mean, he would vie for me. You know, if he had a defendant, he'd say, well, why don't you call Mr. Rogers and see if you can get him to help us. And then he'd just kick right in. I would sign the paperwork, and I was doing paperwork longhand, complete with all of the mistakes. You know, I never even bother correcting anything. I write it once and that's it. He would put his name at the bottom and turn it in. I mean, that's confidence. I mean, he's winning cases. What the hell does he care? Yes, ma'am.
Yes, in Dallas, routinely when you want to defend yourself and refuse a lawyer, you are sent to a psychologist, and that can be a real fun trip. I've been there a couple of times, but I'm wondering if you've ever been to one, and if so, if you've had a lot of fun with them.
Way back when I was in the military, I had a visit to a psychiatrist or a psychologist, but usually they offered to put me in for psychological evaluation, and I merely replied that I would be more than willing to go if at the end of the period of time I was determined to be, what would say, psychiatrically sound, that the moron who thought I wasn't would undergo the same test. They never ventured to continue with it. So you see, for your observation, if you think somebody's insane just because he's acting in a manner in which you don't consider rational, is not proof or even indicative that he's of unsound mind. Now, my method of defending is entirely different. I'm 180 degrees out of sync with what the system is. Every time you read this book and they say to avoid, what we say, reversible error, I'm thinking of how to cause it. That doesn't make me psychologically unsound. It makes me very aware of what these morons can't do. Oh, we have a neat little question. What about state sales tax compliance? Depending on your point of reference, I offer to steal from everybody that I deal with in the public. Almost invariably, they turn me down. If I was on the other side of the coin, if you're, say, running a business in which you have to collect sales tax, I usually resist that business license if I can. If I can't, I inform people that there's a better way to buy. In other words, I can sell to them wholesale. Unless, of course, you got a retail license number, but you can still sell wholesale. But involuntary servitude is prohibited by the 13th Amendment. The state hasn't paid anyone for collecting sales tax, keeping records, or opening and maintaining accounts, or filling out the documents for it. Really? Yeah, now, if you wanted to turn that around, I'd bill them for the full value. Right? Because you cannot be compelled to do something for nothing, or for a minimal amount or a nominal amount. Yeah.
Would there be anything wrong with regards to that sales tax there? At the bottom of the ticket, you put ST and figure out what the percentage is, charge them. That's service trip.
I don't know what the rule provides for. It may be possible, but see, my charges I'm this way. If somebody offered me 10 cents an hour to work for them, I'd decline. So if I had to, by statute, receive 10 cents an hour for my work, I'd still decline. It's a voluntary proposition. What I've tried to get people to see is that a private enterprise, for instance, a private restaurant, available to members only, with no licenses attached. So you start that in your kitchen. So when I come over to your house to eat, in effect, you're feeding somebody from the general public. If I bring my wife and my friend with, and you feed us and we donate for your generosity, what's to be taxed? What's to be regulated? So now if you move down on Main Street and open up your hearts to us in the same way and say, oh, members can eat here at whatever their disposition is. Okay? And then you can suggest that if these members want to keep eating here, they ought to contribute to their own good. Say that the cost of membership is $20 a day, or whatever it happens to be. As long as it's private, there's no tax, there's no regulation, there's nothing required, unless you're open to the general public. Now, there might be some sticky times when you try to get members in who don't exist. How would you do that? Okay, well, you go out and solicit membership. You know, all hungry people, please come. So it's as loose as you want it to be. The other thing we have is property taxes in general. Property taxes are caused by the use. So the use of the property is the state's. And you can see that because the title belongs to the state. And the title is what passes. So they don't care who pays the tax as long as the property is accountable for it. So the tax is levied against the property or its zoning or its use. So the titles are what pass, not the property itself. If you want to avoid property taxes, you need to have the property, what we say, out from under state privilege, i.e. titles. So now the term allodial is bandied about, although allodial by definition refers to title. So allodial title is differentiated from other types of title is nonetheless title. You don't want any title. So I submit that my glasses have no title to them, other than if I want to say they have a title to them. But because I don't have to register their ownership, neither does that apply to my shoes, neither does it apply to any other form of property that I want to acquire and maintain. Now, if I want state recognition or state privilege, I can register certain types of property. For instance, I can register bonds and instruments of debt. I can also register notes or securities. I can also register automobiles. I can also register land or real property. All those are available to me, but I'm not required. We just did a property up in Wisconsin which has no title. It was purchased using the medium of exchange, the most lawful to adjust weights and measures that's available to us. It required no signatures whatsoever. We received a bill of sale. Right? So now, in this condition, it is technically untaxable because there's nobody to send the tax bill to, and you can't send it to the land. And because we're not owners of the land, in this sense, we're the operating stewards of the soil, which is a whole different ballgame. So in that capacity, you're exercising what the Scripture says is the land shall not be sold forever, saith the Lord, for the land is mine. So you're acknowledging it's his. And you don't need a superior to give you title, but you do need to have some competence if you're going to defend that position. So with all you're getting, get understanding. Yeah,
that opened up the question that I've been wanting to ask you.
Go ahead.
I have kind of a unique situation. I've asked Right Way, I've asked John Nelson, so I'm going to ask you, because I still haven't really got a good enough answer for myself.
I don't know if I'm going to tell you the answer, though.
I'm still searching. I was left a house by my grandmother. I traded with my dad, so he has title to the house that I had, and I traded him. He is over 72, so in Dallas County or the state of Texas or whatever, there's no property tax. So that where I live now is still in his name because there's no property tax. And I keep telling him that he put it in the will for me to receive it upon his death. I didn't want to go through probate and all that stuff. And I wondered if I bought it for gold or silver and got a bill of sale from him, or how can I, because you talk about take the title away. I've been told that if I buy it from him and he sends down and says I no longer own this property, whatever, then the county, when you buy a property and you put the title in the county, that gives him ownership. If I buy it from him and I just don't put it in the county, how can I maintain ownership of the property as opposed to going through all the trust stuff? Because I don't even know enough to do that. I'm learning, but am I not, because of the way the system's set up, and I'm a peon or a suburb or whatever, you know, kind of thing they want to call me, can I not own property? Private property?
It's not a problem. It's getting loose from your father without them saying that it was self-serving. See, what they're going to try to do is say that if your father willed it to you, then obviously it's subject to the inheritance tax. Conversely, if your father sold it to you, it's subject to the sales tax and the deed tax. I would suggest you sue the old coot, and for everything he never had. And obviously, if you're capable of suing him, you would settle out of court with him and go down and get the judgment filed, and voila.
Never thought of that.
It isn't the first time it's been done, by the way. But at least it saves the, what would you say, credibility of him testifying or anything like that, or them trying to smear you. Anything else? Yes, sir.
Another question on land. Now, if you're going to buy this land on a private sale, and you don't want the recorded, does the seller send a notification that he sold the land?
Well, you're not concerned. What the seller will do if he's billed for the taxes, will tell him that he sold it.
No, that's when you would notify him that you sold it.
Then they're going to ask who is it sold to. Say, now, depending on how you're relating, what I suggest is when people acquire land that they do so in a manner not known. In other words, yeah, well, you could say agent, but that carries with it a relationship that we were trying to avoid. What I advocate is the use of contract. And in a nutshell, the Evelyn Wood version of it is that for whatever reason, a couple of us gents got together while we were in Canada, and we're visiting from Russia. But anyhow, we got together in Canada and thought we were close enough to this deal that we might want to invest. So we became investors, and because we're foreign nationals or foreign to this country, we appointed you as our agent, in this case manager of this particular contract. And you bought it for the contract. Now, who owns it? Well, the contract does. If you want to add a name to it, you could do that. But nonetheless, because we are nationals, we can't even have possession of the land per se, but the right to contract is protected by law. Right, so that should give you some ideas. But that's the Evelyn Wood version. The mechanics of that are not very difficult. So you just have to forget what you know and invent. And that's what the state's been doing. They invented all this power that they claim to exercise.
So what you're doing is you're giving them some information, but they can't go anywhere with it?
No, I'm not giving any information at all. The purchaser usually wants to know who it's being sold to. So you can just represent lawfully and honestly what you're doing. I'm buying based on a contract I have with some individuals to do so. Okay? It's not unlawful. There's nothing wrong with private ownership of land. Now, what you aren't going to do is register the deed nor allow it to be registered. Say, that's your problem. So the seller doesn't care. If he sends a title, tell him to send that these lunatics took the land and they moved to the moon with it. Haven't seen it since. Okay? The land will always be there no matter what you do. So they don't have to worry about it. Now the problem is, how are they going to tax it? So they lodge the tax in the land, and now they're interfering with the obligation of the contract. Because you have a right to own land or property free and clear of any other claims, so long as it's done lawfully. Okay. That answer your question? Thank you. Anybody else got anything alive? Jay, we run out of questions this early?
I had a bunch.
Oh.
Okay, you said sue him for everything he never had. Do I have to just... This is going to blow his mind when... I mean, he's...
You can be nice about it.
Yeah, well,
you got to remember, you can't openly and notoriously do this. You have to have some conflict.
He's 84. He doesn't understand what?
Yeah.
Yeah.
Isn't there a $600,000 exemption on inheritance taxes?
Yeah, in some areas.
I can't hear you. Repeat the question.
He said, is there a $600,000 exemption on inheritance taxes, which is true in a lot of areas, provided you claim exemptions. But exemptions, like every other privilege, come with a tag attached. Okay. But what you're after is to do what's lawful. The land shall not be sold forever, saith the Lord, for the land is mine, and that a good man leaves an inheritance. Okay. So it doesn't say when it passes. It should pass from the unborn grandson to the unborn great-grandson, as far as I'm concerned, because you're only the steward on the land. And that's the whole option there.
Well, when I sue him for what, and then how does that take the title out of, I'm not real sure I understand.
He, as a condition of the suit, quit claims, because he doesn't have the $800 million to pay you, or whatever you're suing him for.
How can I find something to sue him for?
Fall down the driveway.
I'm very, very devious.
Okay.
I'm probably, if you looked in your pants lately, you're probably shortchanged. Sue him for it. Go ahead.
In Texas, we have the homestead laws, so they sue you. You can't take that property on judgment unless you have some kind of mechanics lien against the property.
See, now you got another avenue.
So,
right?
but so if he settles out of court, say, well, I'll just give you this property as a settlement.
Yeah, that's lawful.
Then he can do such. But then they might not allow said, huh?
You have been learning.
Yeah. What, okay. No, any property that you own. Well, it would consider
we can't hear what she's saying, so they want it on the mic.
Well, she's stating that if you have not filed homestead, then it doesn't fall underneath that.
No, well, it's irrelevant. Actually, if he decides, and it's agreed to out of court, if he sues him for whatever he wants, and they agree out of court, the judgment is just filed with the court of record. You don't even have to have a lawyer. It's just easier if you have a lawyer, and you tell him what to do, and you tell him what to do, and as a condition, you're going to get $1,000. So they just agree out of court, and it gets filed as a judgment. So now the land is quit-claimed, all his right, title, and interest for a cause. And this is the cause, this $800,000 judgment. But, but the mechanics of it are workable. They may vary from jurisdiction to jurisdiction, but it's not unlawful.
I was just wondering, don't you still have to pay taxes on anything you win in court?
No, because if you're injured, you're suing for the injury, so now it's compensation. Unless you're a lawyer, if you win in court as a lawyer, you have to pay taxes on it. If the lawyers were smart enough to take gifts, they'd be better off. There's a few other people out there that have, and I usually tell this little story. A gentleman worked for his own self, if you will. He was self-supporting. And he became, what would you say, too overconfident in what he was doing and injured himself on the job. So he hired a lawyer to sue himself. And in the process became fearful and hired a lawyer to defend himself. And these two lawyers, being obedient servants, settled out of court. So he took a $175,000 compensation claim from himself and wrote it off on his taxes. And wouldn't report it as income because it's compensation. And the IRS lit up like a firecracker. And anyhow, it went to IRS tax court, and you have to volunteer into there. And strangely enough, the IRS judge, or the tax court judge, said the method is lawful. May not like it, but the method is lawful. So take a lesson from the IRS. I've got it somewhere at home. I can get it for you. If you contact Peter, I'll make a point of looking it up. In fact, it was published at one point in the Alert out of Boise, Idaho, which is another great publication in the past. I haven't seen it lately, but really a fine publication as to Patriot issues. Although I'll have to admit that Alfred probably does the best job, and I'm not saying that just because he's here. He's probably the most readable. But anyhow, there's a lot of Patriot publications out there, and there's a lot of mythology out there. What I've done in this particular, they took it out of the IRS rulings, and I went back and looked it up, and that's what it is. So you can depend on the IRS rulings to change, though, with every, what would you say, change of legislation. Okay. So they can change that at any time. IRS court is not a pleasant place to be. You always have the burden of proving whatever you asserted. So they always give you this option, you go to IRS court, which is not court at all. Yes, ma'am.
I have a question on real property. I had always thought that a sheriff's seizure of property and sale on the courthouse steps was only for taxes, but do you know if it can be done on judgments also?
Certainly. It certainly can.
It can?
Yeah. It can be done for any cause, period. In fact, we have them done for mortgage foreclosures. They usually sell the property in the courthouse steps.
Well, true. In this particular instance, the sheriff seized 3 properties on this judgment, and it has to be notarized when he files his sheriff's deed in the deed records, and the notary failed to put her signature on there. Does that invalidate the deed, the sheriff's deed?
Well, it raises the question of its validity. It may not invalidate the deed itself, but it raises the question of validity.
So one would simply file suit and bring that before the court, yeah, and find the case law, yeah, first, as applies to it.
You might raise the firestorm. The other thing they do is they don't sell for money. So there's another argument there. So you can say that this thing was put up for a bid not in money, which may or may not be logical to them. And then, of course, you have a chance to brief it out. But nonetheless, the parties, if you ever got that in court, the parties would now have to agree. So let's say that the bank or the creditor agreed to accept the tender of the purchaser. Now, because that's how the terminology usually comes down, what would it consist of? So that the public would be informed that the sale was lawful. So now you're going to see that only the signatures are what was exchanged. Okay? The agreement of the parties. That's why this money issue is so deadly. If you can get something like that, where it's the agreement of the parties that validates the sale, as opposed to the exchange itself, you can build a lot on it. In other words, the idea of the money question, what is the lawful money of the United States, isn't relevant. It's what they can lawfully compel you to give, as opposed to what they can take. Because they can take the shirt off your back for value, but they have to have a stated amount in money, which relates only to the weight. So somehow, because you have to remain ignorant, if you tell them what the money of the county of the United States is, they say, yeah, we heard that. But this doesn't involve that. So my question is always, what could you compel performance in? See, legal tender isn't a form of payment. It's a form of discharge. Although it's in the vernacular, it's accepted as payment. And with the agreement of the parties, it's legal tender. But it can't be compelled. Otherwise, they could compel you to take Chinese coin. So you could be compelled to discharge your debts in yuan. What kind of crap is that? I don't even know what it looks like. So I wouldn't know how to compute it.
The sheriff's deed says that he acknowledges receipt of the money, and yet money never was offered.
It's a common lie. Oh, there's a nice one you can catch people on. We always have the complaints drawn up by the prosecutor, countersigned by the complaining officer, who usually says that he knows the officer who was on the case, and on information and belief, he swears the following. That's a violation of the law. Now, they also catch them, and in fact, we've had as many as 3 different signatures on the same instrument. So we'll have one say that the undersigned appeared before me, or the aforesigned appeared before me this day, and said the following under oath. Okay? Now, that's a lie. And invariably, as soon as you get there, you call the clerk of court or whoever notarized it, and you ask him the time of day, you ask him the circumstances, what the officer was dressed in, what his comments were about it. Did he read it to you, or did you read it, or did you just rubber stamp it? So you'll find that most of this is fraudulently done. So the sheriff's deed is not the exception. But if you can get witnesses that were there, and all of them say that no money changed hands, if you can get at the mouth of 2 or at the mouth of 3 witnesses, you can cause a real problem over that.
Thank you.
That's worth doing. Yes. Hi, Chief.
I was reading something the other day again, there I go again, about someone who'd actually placed a large lien against their own property to to protect against real estate taxes that he was not paying. And the protection was that the lien was worth more than his property, and of course, if the taxing authority foreclosed, they would have to pay him off on the lien. I just wondered what your thoughts were on that. And I guess the same on that, could